and was very, very public.
I'm well, how are you?
So far, so good.
Just kind of getting out the door.
I understand. You come under me.
All rise for the District Court Contempt. Honorable Judge Eric Moye preside.
Good morning. You may be seated. We are on the record in 2006131, State of Texas versus SB, Hot Mess Enterprises, and Shelley Luther. May I have announcements, please?
Your Honor, Kristen Muncock and Leo Liu for City of Dallas.
City ready to proceed?
For defendants.
Just a minute. Is the city ready to proceed?
Yes, Your Honor.
Mr. Norrie?
Good morning, Judge. Warren Norrie for defendants.
All right.
Judge, I'm not hearing very well.
You need to speak much louder so that the court reporter can hear you.
I understand. I also have one thing wrong. Enclosure is a 3L. It's just,
Judge, I'm still having difficulty. I don't know what's going on, but it's not working as well as it was a few minutes ago.
Okay, thank you very much. We are on for the motion for contempt of the City of Dallas. This motion having found to have been legally sufficient, the court signed a show cause order requiring the defendant to show cause why the corporate entity and the individual should not be held in contempt of this court. At the request of counsel for both sides, the court has reviewed the motion to reconsider the temporary restraining order as entered last week. The court specifically finds that the arguments made therein were indeed made and considered at the time of the temporary restraining order hearing. The motion for reconsideration is therefore denied. Ms. Monkhouse, you're going to drive this bus today?
I am.
I'll hear you very, very briefly in opening.
Loud, please.
Can you hear me okay?
Shout, please. Shout very loudly. As loudly as you can for Ms. Robert.
Your Honor, the issues here are simple today.
Slow down for her as well.
Judge, I'm having difficulty. It's feedback.
Everybody, make sure your microphones are muted unless you are the one speaking, please.
Ms. Monkhouse, it may help if you pick up the phone and hold it while you're speaking.
She just held it up just this moment.
All right, I just started doing that. Can you hear me better, Ms. Roberts?
Yes, very much. Thank you.
Awesome. Okay.
Your Honor,
Your Honor, the issues here today are simple. Your order required the Salon a la mode business to stop operating in order to comply with state, county, and city orders requiring such closure due to the COVID-19 pandemic. But the salon has continued to operate in violation of your order and is continuing to provide in-person hairstyling and nail services. Thus, Your Honor, we're ready to go ahead and put on our witnesses if you are.
Thank you very much. Mr. Norwood, I'll hear you very briefly in opening.
Again.
Closer.
Today we will demonstrate that the salon is not operating as normal.
Judge.
It is taking substantial precautions. The continued operation is not...
Mr. Norwood, the court reporter can't hear you.
Judge.
Thank you.
The court reporter didn't get any infection.
Did you unmute the phone?
I wasn't
aware that it was muted or unmuted.
Okay. Ms. Robert, can you hear him now?
Barely make out what he says. If he can use Miss Monkhouse's phone, that would be better.
I'm sorry, say again, please.
If he could use Mrs. Monkhouse's phone, maybe that would be better.
Doing that now, I believe. Say something for us, Mr. Norwood.
Testing 1, 2, 3.
You need to get a little bit closer to your mask, sir.
I can do that.
Okay, just like that, please. One more time for us, Mr. Norwood.
1, 2, 3,
No,
testing.
no. You're opening.
Oh, sorry.
That's all right.
All right. Your Honor, today we'll put on witnesses and show that the salon is not operating as normal. Its continued operation is by using precautionary methods to ensure the safety of its clients, and its continued operation is not due to disrespect to the court, but of necessity.
Thank you very much, Mr. Norwood. Ms. Monkhouse, call your first witness, please.
Your Honor, the city calls Code Inspector Ashley Gonzalez. She's just outside in the room in order to limit number of people in here at once. Yeah, just go right up there. I think you'll have to unmute the phone. That's up there.
We'll find out. Ma'am, before you sit down, do you solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your full name for, actually, have a seat, please. And you're going to need to hold that phone right up close to you and speak into it. Will you state your full name for the record, please? Welcome to the 14th District Court, Ms. Gonzalez. You may proceed, Ms. Monkhouse.
Thank you, Your Honor. Ms. Gonzalez,
I'm employed as a...
didn't get it.
It's on music. Okay.
Judge.
Did we want her to restate her name or?
Yes, please.
Ashley Gonzalez.
Proceed, counsel.
Thank you, Your Honor. Ms. Gonzalez, how are you currently employed?
I'm currently employed as a code inspector for the city of Dallas.
And how long have you held this position?
3 years.
And what are your
General job duties include inspecting, enforcing city ordinances, or the general job duties.
okay? And are you familiar with the city
regulations? I am.
And are you familiar with the business that's...
I am.
Judge, I'm sorry.
And how did you become...
I became familiar with the property after receiving reports that the business in question was operating at a time when they should not be operating.
Everybody check your phones. Everyone, please, everyone, check your phones. Proceed, Ms. Monkhouse.
Thank you. Have you inspected the business?
Yes.
And when did you inspect the salon?
I inspected the salon on the 24th, 28th, and 29th of April.
Okay. And what was the
reason for having visited on April 9th?
The specific reason was to witness the salon owner being served with a temporary restraining order, and then also revisiting to verify whether or not the business remained open after having been served that order.
And what generally did you observe during your inspection on that date?
I observed clients or people inside the salon receiving in-person service, salon services. I also observed people outside of the establishment. A lot of people outside the establishment.
Okay. About how many people do you think were there?
On the inside or outside?
Both.
Inside, maybe a total of 10 people, including employees and clients. And on the outside, upwards of 20 to 30 people.
Okay. Your Honor, is it all right if I hand the witness a set of photos that she took? Thank you, Your Honor. I could also, if Your Honor would like, I can hand you a copy again. Okay, thank you, Your Honor.
Judge,
Just one exhibit, it's marked as city's exhibit.
Any objection?
Yeah, it's the same photos that were attached to.
Thank you very much. The plaintiff's exhibit 1 is admitted.
Judge, I found out the problem.
Have the witness describe
I look in the photos, and you can take them as they are.
Excuse me, Judge.
Can we slow down on the questions and the answers?
Judge, the problem is I need to mute you. Judge. Judge,
Yes, ma'am.
the problem is your computer, so I have to mute you so I don't get the feedback, but then I can't hear you unless you unmute yourself.
Okay. I can do that.
Okay.
You may proceed, counsel.
Okay, so Ms. Gonzalez, if you could just briefly skim through those and generally describe what is in the photographs.
The photographs depict what I saw during my inspection on April the 29th. They show employees, clients receiving in-person service, and also individuals outside of the salon.
Thank you. Your Honor, the city passes the witness.
Judge, again.
Yes, Your Honor.
Proceed.
Judge, say again.
Ms. Gonzalez, have you ever been on before?
Yes.
Was it operating, how many was it the time before that you went there?
The 24th and the 28th of April? Yes. It is my job to inspect any business inside of the city of Dallas.
I'm still having
You were in
trouble.
that salon before 2020?
No.
Before the events of the virus?
No.
Have you been to other salons?
Yes.
Are you familiar with the requirements of salon operation?
I am not.
Do you generally see?
Judge,
Just a minute. Mr. Norwood, when you hand her
I'm not getting it.
You wish to make an objection?
Yes, Your Honor. I'm objecting as to relevance as to whether or not individuals normally wear masks in salons. The only question before the court today is if the salon is operating for in-person service, not the means by which they may be doing so.
Your objection is sustained.
Your Honor.
It's relevant because your court is going to be asked.
I'm not getting it, Judge. I'm not.
My client is operating or not operating is relevant. If she said, okay, here's what I want.
Judge, I'm not getting this. I am not getting this.
Okay. Yeah.
I'm not, Judge.
The court reporter is apparently not able to hear you at all.
I can be more loud.
Thank
He's
you.
nodding in assent.
Okay, here we go. Your Honor, it is relevant because you are going to be asked to concoct a remedy for my client's alleged misbehavior in violation of the order. It would be one thing if she were just blatantly operating at 100%, pretending that the virus is a hoax. It is different if she's taken some precautions and she can show that if she's not completely doing what you'd ask, she's doing to some degree respecting the court.
I understand your argument. I've made my ruling. The objection is sustained.
Okay. I would ask Ms. Gonzalez, did you see personal distancing going on at the court and the facility?
Objection, Your Honor. Again, the only question is whether or not they were operating. It doesn't matter what measures were put in place as they were operating.
Your Honor, I have a whole series of questions to demonstrate that my client's doing a number of things to mitigate the virus spread. If it's this court's position that all of those things are irrelevant, then just make that ruling and I will cease my questioning. I don't want to waste the court's time by saying things that it's just going to get one objection after another.
The sole issue before this court is whether the defendants operated the salon after having received the court's temporary restraining order, which ordered them to cease the business and to not go forward with the business. There is nothing qualitative in the court's order about how that business could be run or should be run. The only issue was the business run, not was it run safely, not was it run consistent with the CDC or any other guidelines. The objection is sustained.
And I have another question for the court.
Counsel,
Respectfully.
counsel, excuse me. Counsel, be
Is a remedy
quiet.
of $500
Counsel,
this
you
month?
will not speak over me, and you've been in this court before, and I don't want you to do that again. I have made my ruling. If you wish to ask questions of the witness, you are free to do so. If you do not understand the words I just used to you, please just say that, and I'll try to say it again more simply, but I think you understand me. If you have further questions of this witness, you may pose them. That is all I'm going to permit you to do now.
I have no further questions of this witness.
No further questions, Your Honor.
Ms. Gonzalez. Further testimony from the City of Dallas?
Yes, Your Honor. The city only has one more witness. We are going to call Detective Stephen Younger.
Good afternoon. Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God? Will you state your full name for the record, please?
Stephen Younger, badge 6388, Dallas Police Department.
Be seated. Corporal Younger. Proceed, counsel.
Hi, Detective.
Hello.
How are you currently employed?
I'm employed with the city of Dallas.
And what position do you hold?
I'm a Dallas police officer. I'm a risk detective.
Okay. And how long have you held this position?
Approximately 2 years.
And what are your general
Basically, my job duties are to work with a team, an attorney, code, and fire, and we hold property owners accountable for crime on their property.
And are you familiar with the city's emergency regulations related to the COVID-19 pandemic?
Yes, I am.
And are you familiar with the business that's the subject of this lawsuit?
Yes, I am.
And how did you become familiar with the business?
I received an email from the city attorney's office through... I'm sorry, sir. So I had received an email from the city attorney's office through my chief asking me to become involved to do business checks on Salon a la Mode.
And what do you mean by business checks?
Basically, there was a temporary restraining order that was put in place, and I was asked to check the business after the restraining order was issued.
Okay. So on what dates did you inspect the salon?
May 2nd, May 3rd, and May 4th.
Okay. And can you generally describe what you observed during your visits there?
Yes, May 2nd, Saturday, at about I'd say 11:45 a.m., myself and Officer Spence went to the business. When we were inside, before we entered, we saw 2 people waiting outside. When we entered inside the business, there were 2 people getting haircuts and 1 person getting a manicure. I also observed people sweeping the floors, basically cutting hair, conducting business. Also, while I was there, the person that escorted us around, they actually offered Officer Spence and I a haircut. They asked if we wanted a haircut.
And what about when you visited on May 3rd?
May 3rd, we got there approximately 1:45, 1:30, 1:45. May the 3rd, when we had to knock on the door, somebody let us in. There was 1 gentleman and 2 women inside. One of the 2 women were given a manicure.
And what about on May 4th?
May 4th, we got there yesterday. We got there about 11:30. There were several people inside the business. We observed two people getting haircuts, and we also observed another person getting a manicure at the same time. As we were leaving the business, we observed a gentleman walk up. It was a transaction of some type where the gentleman handed somebody a credit card, debit card.
Your Honor, the city passes the witness.
When you went in there, were you wearing a mask?
Yes.
And do you know if Ms. Gonzalez was wearing a mask when she went in?
Objection, Your Honor. That's completely irrelevant as to whether or not the city employees were wearing masks. Again, the only question is, was the business operating?
I know that the court considers this a binary decision, but the court does not have a binary decision for the remedy. The Court of Appeals might think that these things are relevant as to the relative risk. But the one thing to say that the business is operating an open fire or doing something that's crazy, as opposed to something that is a minimal risk and is allowed throughout the city, and is disallowed for this client, this defendant, just because of her profession.
The objection is sustained.
No further questions, Your Honor.
Nothing further, Your Honor.
You may step down, officer. You're excused. Be safe.
Thank you.
Thank you very much. Further testimony from the city?
Nothing further, Your Honor.
Mr. Nora, do you wish to call a witness?
Call Ms. Luther.
Come forward, be sworn. solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God? State your full name for the record, please.
Shelley Luther. Shelley Luther.
Welcome to the 14th District Court. Please be seated. Speak right into the phone.
Thank you, Your Honor.
Ms. Luther, what do you do for a living?
I own a salon.
The salon that's subject to this proceedings?
Yes,
Are you a licensed stylist?
I am not.
How long have you operated your facility?
Since October of 2017.
Can you describe the size and briefly describe your salon?
My salon is about 3,600 square feet, with stations spread out about 6 feet apart each. It's pretty wide open.
How many chairs do you have?
I have about 25 chairs and 2 manicure stations and 3 suites.
And how many of those have been operational in the last few weeks? Or last week?
The most that we've had in there is 5 stylists at one time, and that's the most. It's usually been just 2.
And why did you reopen?
Because I had no other choice, because I couldn't feed my family.
Does your business receive the loans from the federal government that's been so popular in the media?
We filled out the applications right away for those loans, and we were not granted those loans until 2 days ago. I received one.
And so you reopened when?
April 24th.
And are you operating as normal?
No, we're not operating as normal.
So describe briefly the differences between your normal operation and what you're doing now.
Objection, Your Honor. Relevance, again, basically the same I've already asserted. We're only talking about whether she's operating, period, not in what
I'm going to
capacity.
let the witness testify. The objection is overruled. I will not consider irrelevant testimony.
Can you please ask the question again?
Can you describe the differences between your normal operation and your operation as you are now?
Yes.
Please do.
Normally, we have about 19 stylists and 2 nail techs working on and off, a lot of times at the same time. Right now, like I said before, we only have a few that are working. I have put up several hand sanitizer stations. I do not allow potential clients to come inside until their stylist is ready. I have chairs sitting 6 feet apart outside for potential clients. All of our hairstylists are wearing a mask at all times, and so are the clients. I took away all the magazines and any of the drink stations that could be universally used. And we are, of course, following all of the TDLR recommendations for hygiene and sanitary requirements.
Give me about a 10-second version of what your stylists have to know as far as hygiene.
Well, they are required to have about 1,500 hours of hygiene and sanitation training in order to receive their license. And they have to renew that every 2 years. And we're also inspected by TDLR.
Ms. Luther, do you have respect for this court?
Absolutely.
When you received the TRO, did you not?
I did.
So why are you continuing to operate?
I had no other choice because I couldn't feed my family, and my stylist had a hard time feeding their family as well.
Do your stylists get paid by you, or how does that work?
No, they are directly paid by the clients.
So you have a contractual relationship with each stylist that comes in and does the work there?
I do, but they have not given me any money at all since the shutdown of March 22nd.
Do you believe that the TRO is enforceable, or do you have an opinion on that?
Sorry, Judge, I didn't get that. Judge, I didn't get her objection.
That objection is sustained.
Judge, I didn't get that objection.
Further questions?
Just a couple questions, Your Honor. Ms. Luther, you had mentioned that you finally received a loan a couple days ago, I believe. Is that correct?
I did. I applied for 2 loans from the SBA, one through Chase Bank and one through the SBA directly, and I had not received any kind of contact from them at all. But when I opened my bank account and looked at it on my phone a couple days ago, there was money in there, and I couldn't confirm what it is. I'm assuming that's what it is.
Okay. And so are you still operating since having received the loan?
I am operating, but because I'm not sure I'm allowed to spend the loan, and even if that's what it is. So I don't want to just spend money recklessly if I don't know what it is yet.
No further questions, Your Honor.
Concerning that loan, is it your understanding that you have to employ people in order to not pay it back?
From what I've read, if it is the PPP loan, I have to pay employees in order to have part of that loan a grant.
Thank you. That's nothing further, Your Honor.
Judge, repeat that.
Ms. Robert, can you hear me?
Yes.
Is the salon operating today?
Partially, yes, sir.
All right. Who owns S&B Hot Mess Enterprises?
That is my DBA, sir.
It's styled in the lawsuit S&B Hot Mess Enterprises. Is that an LLC? Is it a corporation, or is it just DBA?
Sir, it's an LLC.
Who owns the corporation?
I own everything.
Okay, thank you. You may step down.
Thank you, Your Honor.
Further testimony from the defendant.
Your Honor, I expected to call Dr. Huang today, but I don't see these here, and I guess because we talked about this, but I expected him to be here. I did not, because we talked about it, and it seemed like it was pretty clear that he was going to be a witness here.
Do you have further testimony you wish to offer, counsel?
No, but I would like to offer into the discussion. Well, we have the unsworn declaration of Dr. Keith LePack, which is Exhibit 9 to the motion to reconsider. I'd like to have that entered as evidence.
Your Honor, the city would object based on relevance. Doctors' opinions don't speak to whether or not Ms. Luther and the salon Alamo business are in contempt of this court, and that's all that's before the court
The
today.
objection is sustained. Further testimony from the defendant.
None, Your Honor.
None, Your Honor.
Further testimony from rebuttal testimony from the plaintiff.
Nothing further, Your Honor.
I will hear briefly from the city in closing, a little bit more expansive than your opening if you are so inclined.
Thank you, Your Honor. As you're well aware, we're here today because you issued a TRO requiring the salon Alamo business to cease operations for in-person services. That order was made due to the various state, county, city orders that have been put in place related to the COVID-19 pandemic. As you heard from the city's witnesses, first, Code Inspector Ms. Gonzalez, she visited the property the day after the TRO was issued and witnessed it being served on Ms. Luther in the business, and also went back another time to see if maybe Ms. Luther had changed her mind and decided to close the business in response to getting the TRO. It was clear upon Ms. Gonzalez's second visit that she was still operating. There were still people inside receiving hairstyling or nail services, and there were people waiting outside to go in and obtain those services as well. The city's second witness, Detective Younger, he also followed up to determine if the business had changed its mind and decided to close to comply with this court's order. He visited the salon on May 2nd, 3rd, and 4th, and on each of those occasions was able to enter into the business, observe people obtaining haircutting or nail services. He witnessed a financial transaction take place, and it was just clear that the business in general was still open and operating in whatever capacity that may have been. Again, Your Honor, you're well aware that your order required all operations to cease. It doesn't matter what capacity she may have been operating. Operating at all is the issue that is here and poses a risk because of the COVID-19 pandemic. Thus, Your Honor, the city is asking today that you hold Ms. Luther and the business in civil contempt and assert a $500 fine per day for while she is operating until she complies with your order, or until such time as that order gets superseded by a temporary injunction. Yes, Your Honor.
Forgive me, proceed.
Okay. And or to confine Ms. Luther to jail for a maximum of 180 days, whichever Your Honor seems appropriate, the city is happy with. We just pray that you hold Ms. Luther in contempt and at least fine, if not jail her, for violating your order.
And for you, if you're through?
Yes.
You mentioned that the defendant was in civil. The restraining order required her to cease doing business, correct?
Yes, Your Honor.
Failure to cease doing business would be criminal contempt, would it not?
Yes, Your Honor. And the city's motion for contempt covered both criminal and
I wanted to
civil.
make sure that you had not abandoned that claim. Thank
Yes,
you
Your
very
Honor.
much. Mr. Norwood, I will hear from you briefly as well.
Your Honor, as to the question of whether Ms. Luther has violated the TRO law, if it's treated as though it's a binary question or a binary an answer, and that answers all things, then of course she's violating it in the way that she's partially open. However, it's not a binary question because this court has a range of remedies that it can order. It can order her to jail. It can order all sorts of things, a fine. We'd ask that the court take into effect the fact that Ms. Luther has to work in order to earn her money. In order not to pay back the loan, she has to employ people. She just can't give them the money. They have to work. And if we were allowed to provide evidence, we would show that it's not a matter of saying it's a pandemic and therefore we have to treat everything as though it's on fire. There is a minimal risk that we are willing to take. That's why our daycares are still open. And we would also suggest that if the court is going to have a finding of contempt, that if a material change to the governor's executive order allows salons to open, that this order should have some mechanism in it to say that that's automatically going to have an effect of some sort. I'm happy to answer any questions, Your Honor.
Judge. Judge, I didn't get any of that. You were muted.
Can you hear me, Ms. Ribier?
I can now. Will you please start over?
I don't think that the city would dispute now 3 times that if this court entered a finding of civil contempt that would be vitiated by any subsequent ruling by announcement or executive order by the governor. Do you agree?
Yes, Your Honor. To the extent she's already violated the order and is continuing to do so at this time, the city still holds that contempt should be.
Well, that's a little bit different question. Mr. Norwood,
sorry, Your Honor.
back to you. If the governor were to make a pronouncement that phase 2, which would include salons, could reopen, is it your position that that would impact a finding of criminal contempt?
Certainly, as to the remedy, you bet. I think that Your Honor, Ms. Luther's attitude does have to have some
I'm not
impact.
asking you about her attitude. I'm not asking you about that at all. My question is very pointed. Is it your position that an advancement of phase 2 of the governor's executive orders to open more businesses, including salons, would impact a finding of criminal contempt?
Certainly going forward. Is that your answer question?
No, it's not. All right, thank you. I understand, Mr. Norwood. I said no more questions, but I've got one more for you. Please forgive me. I understand from our conversation yesterday that you think that the governor's conference this afternoon might materially impact what we're going to do today. Is that still the case, sir?
I have no secret knowledge, Your Honor, but I believe that it's a material risk. Let's put it that way.
All right. Thank you. This court makes the following findings. On April 28th, 2020, this court entered a temporary restraining order. The defendants were served with that order the same day. The order specified that defendants were to cease operation of their business salon a la mode. Order further enjoined and restrained the defendants from continuing the operation of the salon. The defendant S&B Hot Mess Enterprises LLC is a limited liability corporation wholly owned by the defendant Shelley Luther. Each of the acts described herein of the limited liability corporate defendant were undertaken by the individual defendant. On April 29th, 2020, defendants, despite having been served with the order, refused to cease operations of the salon. The evidence adduced at this hearing, without contradiction, established that the defendants continued the operation for several days after the entry of this order, and which is 7 days ago, and have continued to do so to this date. Customers of the salon were present each day, receiving services in the salon. The evidence indicated that employees of the salon performed services on clients, which by necessity, including working with direct contact with said customers, including haircuts and manicures, ignoring the city and county requirements and the Center for Disease Control recommended guidelines that individuals respect a 6-foot social distancing zone in which other individuals would not enter. The refusal of the defendants to cease operation of the salon, despite the clear and unambiguous language of the order of this court, which instructed them to do so, constitutes criminal contempt of this court. The continued operation by the defendants of the salon despite the clear and unambiguous language of the order which prohibited defendants from so doing, constitutes civil contempt of this court. We are going to stand in recess for approximately 45. I am going to wait for the, actually, I'm sorry, I've got one more thing I want to put on the record. The executive order GA-18 of the governor of the state of Texas, signed April 27th, 2027, requires all Texans to minimize in-person contact with people who do not live in the same household, except where necessary to provide or obtain essential services or reopen services. The opening of the salon in any way, shape, form, or fashion violates that executive order. It violates this court's temporary restraining order. It violates the city of Dallas and Dallas County's orders with regard to this pandemic, putting the citizens of the state of Texas and the county of Dallas at unnecessary risk. On April 30th, 2020, Ken Paxton, the Attorney General of the state of Texas, wrote, "The executive order requires all Texans to minimize in-person contact other than where necessary to provide or obtain essential services." The Attorney General went on to say, "Some services that are neither essential nor reopened services for the purpose of GA-18 include..." Sit down and be quiet. I am not through speaking. Do not say another word while I'm speaking, and you will not interrupt me again in this court, Mr. Moye. These services that are not essential or reopened include bars, gyms, public swimming pools, interactive amusement venues, or cosmetology salons. I have no doubt about the sincerity of the defendant in what she has said here and elsewhere. The rule of law cannot and does not operate when individuals take it upon themselves to decide what they can do, what they cannot do, what they will do, or what they will not do. This court specifically finds that the violation of its order was willful, was flagrant, and was very, very public. Those are factors the court will consider, among others, in making a determination of punishment. There's an axiom in contempt jurisprudence that suggests that often the respondent has the keys to the jailhouse. While we are awaiting the pronouncement from the governor, I'm going to give the defendant an opportunity to consider whether she still advocates for the position that because she felt she had to, she could violate the order of the governor, or more particularly for all purposes, the order of this court. We are going to stand in recess for approximately 45 minutes. Ms. Luther, you may not leave this courtroom until I have discharged you. Sheriff, I'm instructing you that if Ms. Luther leaves the courtroom, you will restrain and you will detain her. If you need to use our facilities, the sheriff will take you into our jury room so that you may do so. I know where my rooms are, I know which rooms I want used. We will be in recess. We are back on the record in 2006131. I want to start by acknowledging an opinion from the Supreme Court of Texas delivered this afternoon, denying a writ of mandamus which was filed by the defendants in this matter. We're not going to need that. Yes. One second, please. It reads in salient part, Constitution is not suspended when government declares a state of disaster. In the weeks since American governments began taking emergency measures in response to the coronavirus, people of this country have graciously and peacefully endured suspension of their civil liberties without precedent in this nation's history. Nearly everywhere, the First Amendment rights of people to peaceably assemble have been suspended altogether. Tens of millions can no longer earn a living because the government has declared their employers or businesses non-essential. Those who object to these restrictions should remember they were imposed by duly elected officials vested by statute with broad emergency powers who makes difficult decisions under difficult circumstances. Any government that has made grave decisions to suspend liberties should welcome the opportunity to demonstrate both to citizens and the courts that its chosen measures are absolutely necessary to combat a threat of overwhelming severity. Ideally, these debates would play out in the public square, not in courtrooms. No court should relish being asked to question the judgment of government officials who were elected to make difficult decisions in times as these. However, when properly called upon, the judicial branch must not shrink from its duty to require government's antivirus orders to comply with the Constitution and the law, no matter the circumstances. This original petition, that is, the petition challenging this court's right to proceed, which challenges several local officials' virus response measures, must be presented to the appropriate district court. The petition for mandamus is denied. Moments ago, Governor Greg Abbott ordered that among services which were going to be allowed to be opened would include, as of May 8th, barbershops and cosmetology salons, which takes care of a part of the issue before us. In Dallas County yesterday, there were 237 new cases of COVID, a total of 4,330 in our county. 77% of the hospitalizations are people in designated essential businesses. That's what we face now. We will continue to face this until a cure is found, or we are all immunized, naturally or otherwise. Until that time, it is imperative that the instructions of our elected officials from the state capitol to this courthouse are respected and followed. Failure to do so will only have catastrophic consequences, and those reach far beyond the exigencies of one family or one business. In Luther, there may be circumstances which you genuinely believe are acute. You may believe that these mandate your actions in open, direct, and notorious violation of the orders promulgated by our elected officials. Hopefully, this experience has brought you to the realization that because you believe there's something you want to do, you do not have the right to independently supersede state law. A determination has been made that you are in contempt of this court. You refuse to shut down your business in the face of a restraining order which required you to do so. We continue to operate your business for a full week, even after being ordered not to. Earlier, reference was made to your having keys to the jailhouse. You may utilize them now. If you would like to take this opportunity to acknowledge that your actions were selfish, putting your own interests ahead of those of the community in which you live, that they disrespected the executive orders of the state, the orders of the county and this city, that you now see the error of your ways and understand that the society cannot function where one's own belief in a concept of liberty permits you to flaunt your disdain for the rulings of duly elected officials, that you owe an apology to the elected officials whom you disrespected or flagrantly ignoring, and in one case defiling their orders, which we now know obviously apply to you. That you understand that the proper way in which in an ordered society to engage concerns which you may have had is to hire a lawyer and advocate for change, an exception or an amendment to laws that you find offensive. That you publicly state that this is the way that citizens in the state should behave. And that you represent to this court that you will today cease operation of your salon and not reopen until after further orders of the government permit you to do so. This court will consider the payment of a fine in lieu of the incarceration which you've demonstrated that you have so clearly earned. Is there anything that you would like to say? You must stand up if you speak in this court.
Judge, I can't hear. I cannot hear her.
Can you assist us? I know, we're trying to find it. Oh.
Judge, if you'll mute yourself, please. If she's talking, I'm not hearing her.
Hang on just a second, ma'am. Just say a few words. Give us a test.
Test.
Yes.
Better?
Better.
Okay, you may proceed.
Judge, I would like to say that I have much respect for this court and laws. And that I've never been in this position before. And it's not some place that I want to be. But I have to disagree with you, sir, when you say that I'm selfish, because feeding my kids is not selfish. I have hairstylists that are going hungry because they'd rather feed their kids. So, sir, if you think the law is more important than kids getting fed, then please go ahead with your decision, but I am not going to shut the salon.
Earlier, I stated findings and conclusions that I made with regard to this matter. It is hereby ordered, adjudged and decreed that defendant Shelley Luther, having been found in criminal contempt of this court, is hereby remanded to the custody of the sheriff of Dallas County as punishment for her violation of this court's order. Defendant Luther shall be confined to a penal facility of the choosing of the sheriff of Dallas County, where you will remain for a period of 7 days, 1 day for each day that you violated this court's order. It is further ordered that the defendant, having been found in civil contempt of this court, shall hereby be remanded to the custody of the sheriff of Dallas County as punishment for your failure to comply with the order of this court. Defendant Shelley Luther shall be confined to a penal facility in the choosing of the sheriff, where she will remain for a period of 7 days. It is further ordered that the penalties, both civil contempt and criminal contempt, shall run concurrently. It is further ordered that defendant S&B Hot Mess Enterprises, having been found in criminal and civil contempt of this court, is hereby ordered to pay a fine of $500 per day for the 7 days in which it has remained in business, and will be paid within 30 days of the date of this order. Further ordered that defendant Hot Mess Enterprises, having been found in civil contempt, is hereby ordered to pay a fine of $500 per day for each day from this day going forward in which the salon remains in operation through May 8th. Sheriff, take this defendant into custody, if you please. An order of judgment of contempt and commitment will be online directly. Anything further from the city? Anything further from the defense? Thank you very much. We are in recess. You are all excused.
Live stream off.